We are moving on with our discussion on company law. Now, in company law, today we will be handling a very critical area, which is actually doctrine of a company. Now, in the doctrine of a company, we'll do the introduction. What is doctrine? The codification of beliefs or a body of teaching or instruction, thought, principles, or position as the essence of teaching in a given branch of knowledge or in a belief system. So when you talk about a doctrine, it's just a rule. We have doctrine in religion, we have doctrine in companies, we have doctrine in businesses. So when you come to company law, this is just a rule of action, a way in which companies are supposed to do their operation in terms of management, how they relate with the company management, how the management relates with the outsiders. So these are critical areas in company law. So the law which governs the management of the company. So these are laws which will govern the management of a company. Types of doctrines. 1. Ultra bias. So doctrine of ultra bias. We have doctrine of constructive notice. 3. Doctrine of indoor management. So these are the critical types of doctrines. For the management of a company to be successful, these doctrines must be applied. We are protecting the company. At the same time, the outsiders are being protected. So with the ultra vires doctrine, constructive notice, and indoor management, every area of the company is protected and the outsiders. So we start with the ultra vires doctrine. Ultra vires is a Latin word, ultra meaning beyond, vires referring to natural power. So when you talk about ultra vires, the phrase means beyond power. So it's beyond power. When someone acts beyond the scope of the authority or power that is granted to him by the law, contract, or agreement. So anybody who is acting beyond the powers which are granted by the authority or power or an act or a law is said to be ultra vires, beyond the powers given by the authority or the government or the company. The action that is beyond the power that is granted in the law is deemed as invalid. So when you take any action, when your operation with the company is ultra vires, we say your action with the company is invalid. It's not recognized in the law. So you need to be very careful when you are dealing with a company, because any deals, any agreement, any contract that you are engaging with a company, it has to be intra vires within the company's memorandum of association and article of association. Types of ultra vires. There are 3 types of ultra vires act, which includes the following. Ultra vires, the memorandum by the company. That means any action which is against the memorandum of association is termed as ultra vires by the company. So they are acts performed by the company that are beyond the powers granted to it in the memorandum. Number 2 is ultra vires the article, intra vires the company. What do you mean by that? These are acts performed beyond the powers granted to the company by the article of incorporation, but that are still within the powers of its memorandum. So any action which the company is acting on, which is ultra vires the article but intra vires the company. That means it's against the article, but it is within the company's memorandum. Number 3, ultra vires directors, intra vires the company. That means any action which is against the power of the directors, but within the company's memorandum, is actually established as ultra vires the director. It is against the authority of the directors, but it is within the company's memorandum, is deemed as valid. Ultra vires act cannot be ratified. In other words, ultra vires act cannot be declared valid while it has been invalid. The rule is meant to protect the interests of the shareholders and the creditors of the company. So this rule is for the benefit of the shareholders and the creditors. Effects: personal liability of the directors. That means ultra vires, any action which the director does against ultra vires is deemed to be null and void. Ultra vires acquired property. Any property acquired which is against the memorandum is termed invalid. Ultra vires lending. When the company is lending money which is against the rules and regulation is ultra vires lending. Ultra vires tort. These are rules and regulations which are based on the running of a company. Constructive notice. This is number 2, doctrine. The doctrine said that before dealing with any company by anybody, they have the right to inspect the company documentation. So it is the right of any investor, any individual, any shareholder to inspect the documentation of a company before entering into any deal. Company Act 2013 Section 399 specifies the rules and regulations governing the inspection, production, evidence of documents with the registrar. So it is actually your mandate to make sure that you inquire, you do your investigation and find out whether the company has done the right documentation, whether the memorandum of association is in place, whether the article of association is in place. They must inspect the documents and establish conformity with the provision. Even if a person fails to read them, the law assumes that she or he is aware of the contents of the document. So it's very critical document. If you go against this document, you face the reality. So the document protects the outsiders. The document protects the company from the outsiders. The doctrine is opposed to the constructive notice. So indoor management is actually a document which deals with the management of the company. The doctrine protects the outsiders from the company management. Remember, it is stated that the company inside management is their role to play and do the right thing. If they don't, it's not the work of the outsider, but it is the work of the insider. So the management must do their work. Directors must do their work. The doctrine argues that outsiders dealing with the company are assumed that everything had been regularly done so far as it is internal proceedings are concerned. The doctrine had its origin in a famous case of Royal British Bank versus Taquan. Case law. The Royal British Bank versus Taquan. This is a very interesting law whereby the Royal British Bank offered to lend a bond, or they sold a bond to Taquan. Now this bond was sold to Taquan without the resolution of the company's annual general meeting. So what happened is that it is against the law. But the doctrine is, however, subject to the following exception. Knowledge of irregularity A person who deals with the company and who has knowledge of irregularity in its internal management in connection with the subject matter of his dealing cannot claim benefit of the rule. That means if you are aware about the regularity of the company and you're still making deal with the company, then you'll not benefit from the rule of indoor management. Number 2, negligence. The person cannot claim the benefit of the rule in the circumstances under which he will have discovered the irregularity if he had made proper inquiries. So it's upon the individual, before making any deal with the company, inquire so that if there are any irregularities, you can avoid making any deal with that company. Forgery. The person cannot claim the benefit whereby the document on the deal was due to forgery. So if the documents which were involved in deal are based on forgery, so that person cannot claim the benefits of indoor management. So indoor management protects the outsiders from the company. So it's the work of the company to play their role, do the needful, do the rightful. That brings us to the end of doctrine.